3 defendants, 1 courtroom, and a judge who wasn't playing games. A man fighting to stay out of jail, a woman defending herself without a lawyer, and another defendant warned he could face jail again if he ignored court orders. What happened next inside this Wisconsin courtroom shocked everyone.
Preliminary hearing, and one is a bond modification request. The court has in front of it a signed waiver of right to preliminary hearing document. Do you recognize this document, Mr. Cook?
Yes, ma'am. Yes, Your Honor.
Did your attorney go over this document with you thoroughly,
Yes, Your Honor.
essentially word for word,
Yes, Your Honor.
and you understand everything completely?
Yes, Your Honor.
Did you sign that document?
Yes, Your Honor.
Do you understand once you waive the right to a preliminary hearing, it is forever and you cannot get it back?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
I will find that you are freely, intelligently, and voluntarily waiving the right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Schmidt,
I filed the information. It mirrors the criminal complaint.
proceed with an arraignment or set for another date, Mr. McLaughlin.
I would prefer another date, Your Honor, because the issue of, I have not reviewed with him, for example, the issue of judicial substitution, which is an arraignment deadline. So therefore, if the court would allow, I would be more comfortable with a separate date. Let me get in my calendar, please.
You can have tomorrow morning
Tomorrow morning would be fine.
and 10 o'clock, or how about 10:30?
10:30 tomorrow would be
One
fine.
sec before we schedule out.
Well, yes, that would be fine.
Okay, yeah, that works. Sorry, I was thinking of a different day.
Okay, 10:30 tomorrow morning. Sounds good. Bond modification request. Would you like to argue it today or tomorrow?
I would prefer to argue it this morning, Your Honor. It had been noticed for today.
All right, then you may continue.
Your Honor, the defense, first of all, would like to acknowledge the seriousness of your charge and not to deny that. However, the defense believes that the defendant has substantial, essentially lifelong ties to the community. He has dutifully employed Ms. Kara Boyer, who is a longstanding Burnett County employer. For over 25 years, she's owned the Dairy Queen restaurant chain, one of which is his here in Siren. And she is here to state, I will just make an offer of proof without testimony unless requested, that she is willing to not only provide transport for Mr. Cook to ensure his appearance for court appearances, but also she and her brother Kent are going to be willing to post up to $3,000 cash surety on his behalf to ensure his appearance. Again, I believe that $3,000 is a substantial sum of money. Mr. Cook has a substantive, reliable employment relationship with the Boyers. They are obviously longstanding, relevant community members. Ms. Boyer and I spoke of the fact that she's involved with the recovery community. Obviously, absolute sobriety will be a condition of any bond that Mr. Cook would have to abide by, and Ms. Boyer is willing to assist Mr. Cook in his recovery efforts, assuming arguendo that those are necessary. So I believe, Your Honor, that defense acknowledges the seriousness of the offense, but given the standing of a substantial community member, as well as Mr. Cook's, as I've recited in my motion papers, his relatively modest prior criminal conviction history. As far as Wisconsin CCAP goes, I don't have access to international and national database, but he has 2 prior misdemeanor convictions according to Wisconsin CCAP, and therefore does not have at age 46, does not have a long-standing substantive criminal record. Therefore, Your Honor, for these foregoing reasons, I believe that the motion to modify is based on new factors that were not entirely in front of the court at the time of the original setting of bond. Thank you.
All right, thank you. Mr. Schmidt?
The state takes no position on this.
All right. Well, Ms. Kara goes back even further than the Dairy Queen to the fancy phrase. And that's what I remember when I was growing up. And then I believe the Frederick Dairy Queen, and then the Siren Dairy Queen. She is a respected member of our community. Mr. Cook, because she is willing to back you, the court is willing to amend bond to the 3,000 cash with the same conditions. No driving. You don't have a driver's license. And you've been working on getting that driver's license, and you have to continue to work at getting that driver's license. And so based upon that, and because you do have the support, don't let her down.
Oh, I won't.
Let the community down. Don't let this court down. So the absolute sobriety, those same conditions will remain in effect. You're coming back tomorrow. We'll go from there and we'll see what's happening with the case. So the court will amend the bond at this time. I am going to, as a condition in the bond, that someone, I don't know if Ms. Boyer, are you going to be the one solely responsible for ensuring that he gets to court?
I will pick him up. You said tomorrow at 10:30.
Yes.
I have one question to that. I have to have my mom at the United Hospital tomorrow, and Kent and I will be leaving around noon. We have to be there at 2 o'clock.
It'll be a 5-minute hearing.
Then that will be fine.
Yeah, it won't be too long at all.
And for the clerk's record, Your Honor, I'll give his address if that would be of benefit. The address I have is 7354 Main Street East, apartment 16 in Webster, Wisconsin, 54893.
Mr. Cook was just recently in front of the court for other matters. I'm aware of his address.
I just wanted to, in case that it wasn't known by the clerk, Your Honor, pardon me.
That's why I stressed the no driving without a driver's license.
Yes, Your Honor.
All right. Okay. Thank you. We'll see you tomorrow. We're adjourned.
I'll see you tomorrow. I'll be early. You be a little bit early, okay?
So tomorrow here at 10:30, right?
10:15 for you.
Okay, not a problem.
Thank you.
Oh.
We can talk briefly.
Court dates. Hard to get through. We will go on the record in the matter 21 CM 112, State of Wisconsin versus Angie Jones. The state appears through District Attorney Kevin Schmidt in person. Ms. Jones appears in person without counsel. We're set here today in this matter. It's a status conference, but you were here at the initial appearance. This is a burial case. And an offer was made to plead to the charge, I believe, with the lowest possible guidelines and to deem the refusal as reasonable.
That's correct, and dismissing the reading and the resisting.
All right. And so Ms. Jones, you were going to think about that. I believe I explained to you what it meant if you were going to enter a plea and all of that. Have you had an opportunity to think about it and to talk to people if you wished, even an attorney?
I did have some time to think about it, and I made an attempt to, two attempts to contact the district attorney's office to see if there could be some minor alterations.
In a packed Wisconsin courtroom, Judge Melissia Mogen presided over a dramatic series of hearings that revealed just how quickly lives can change inside the justice system. The first case involved William Cook, who appeared in custody facing serious criminal charges. Cook officially waived his right to a preliminary hearing after confirming multiple times that he understood exactly what he was giving up. The judge carefully questioned him to ensure no threats or promises had influenced his decision. But the biggest moment came when Cook's attorney requested a bond modification. His defense argued that Cook had lifelong ties to the community, stable employment, and the support of respected local business owners willing to post a $3,000 cash bond on his behalf. One of those supporters was Cara Boyer, a longtime business owner connected to the Dairy Queen restaurants in the area. The defense stressed that Cook had only a limited criminal history and strong community support. After listening closely, Judge Mogen agreed to reduce the bond. But she issued a direct warning from the bench. Don't let this court down. The judge ordered Cook not to drive without a valid license and reminded him that violating any condition could land him right back in jail. Next came the case of Angie Jones, who appeared in court without legal representation. Jones explained that she had tried multiple times to contact prosecutors about changing parts of a plea agreement, but had been unable to reach anyone. Judge Mogen temporarily paused the hearing and encouraged Jones to speak directly with the district attorney. At the same time, the judge warned her about the dangers of representing herself in court, making it clear that prosecutors could explain the law, but could not provide legal advice. Then came another tense hearing involving Tyler Wilson, a defendant who had previously failed to appear for a supplemental examination. A warrant had already been issued for his arrest before he finally returned to court. Wilson was placed under oath while attorneys demanded financial documents and records connected to the case. The judge ordered him to provide all requested documents within 2 weeks and warned that failure to comply could result in contempt charges and possible detention. At one point, Wilson directly asked the judge whether he needed an attorney before answering questions. Judge Mogen refused to advise him, simply reminding him that the hearing would move forward regardless. Across all 3 cases, the courtroom atmosphere shifted between tension, legal pressure, and brief moments of humor. But one thing remained consistent. Judge Mogen made it clear that accountability mattered, and every person standing before the court would be expected to follow the rules.
Court sort of reorder Mr. Wilson to produce all the documents that were previously ordered. I have copies of the original order with me here that I can provide to the court and to Mr. Wilson. It also occurs to me that as we're talking, I might identify a few more specific requests. The original requests are sort of broad because I didn't know what I was talking about yet. So if it's all right with you, I'd like the ability to both sort of reissue those kind of blanket requests and also order Mr. Wilson to produce all of any specific document that I ask for within, say, 2 weeks from today.
All right. And so, Mr. Wilson, when you were originally served the first matter for this supplemental examination, there was a list of all the documents that Mr. Sullivan was asking for. Did you bring any of those documents with you today?
No, ma'am.
Okay. And so the court is now on the record. I'm ordering you to provide those documents 2 weeks from today, which would mean it would be by May 5th to have all of those documents provided to Mr. Sullivan. Mr. Sullivan will provide you another copy of the documents that he is requesting. And Mr. Sullivan, is that in my file or do I need to now place it in my file?
I don't believe you issued that order, Your Honor. It was Commissioner Benson that did. I happen to have I have an extra copy of it if you'd like to take a look at it.
Does it have a stamp up there that says document number or something?
I don't believe so. Let me check. No, it does not.
All right. So then what I'm going to need is for you to file that with the court as well, so I know what I am ordering him to provide.
Okay.
And then upon receipt of those documents, Mr. Sullivan, I am ordering that you provide an update to the court, letting the court know that he has complied or he has not complied. If you do not comply, Mr. Wilson, that means the court can issue that capias again to have you bound and held until we have the hearing, and you will be ordered to get those documents probably before you're released. So it's very important that you look for those documents. If you do not have those documents, if there's something missing, then you must provide a full explanation, not only to Mr. Sullivan, but to the court as well. So I'm kept in the loop of what's going on. Mr. Sullivan, what else are you asking of the court?
I was going to ask that in addition to, and perhaps this is the way to handle this, is to include this when I file a copy of the original order. In addition to those sort of blanket requests, I thought it might be helpful to include more specific document requests that would kind of come up as we're discussing, as I'm questioning Mr. Wilson today, if that's something that Your Honor is comfortable with.
Yes.
Okay.
I mean, if there are documents that you...
It's sort of belt and suspenders because I think everything specific that I would ask for is already covered within the sort of blanket requests previously, but however you prefer to handle that.
That's fine. Go meet with Mr. Wilson, and you can go in our Zoom room, attorney room, and go over the information. If you believe that there are other documents that you're going to need, and you want to place that on the record, we can get back on the record. But I can let you know, I have to leave early today for a track meet.
Understood. Okay. I guess one other thing to address before we get started, Your Honor, is I think I misunderstood. I didn't arrange for a court reporter to be here to take notes of our examination. If it's okay with Mr. Wilson, I would suggest that just so that my own notes are not the only record, if I could just record audio on my cell phone that I have with me, if there's no objection from Mr. Wilson to that.
Mr. Wilson, you would be able to request a copy of that as well, and he would have to provide it.
Oh, I agree.
Okay, he
Okay.
agrees. That makes sense. All right, anything further from you, Mr. Sullivan?
Not right now. No, Your Honor.
Okay, thank you. Mr. Wilson,
Yes, ma'am. You asked Mr. Sullivan if he could explain other things that he wanted from me, information. He hasn't provided that explanation to you yet. Further, do you think that I need an attorney with me when I talk to Mr. Sullivan?
do I know? It's not for me to say, that's for you to say. And the fact is you have a capias to be here for this exam and you're not getting out of it. Sorry. So you're going to do the exam here today.
Okay.
And I believe Mr. Sullivan came from Madison, Milwaukee, down south.
Milwaukee. Yes.
So
Well, I think we both traveled today, so.
you came from, what place is that? The little road place not far from St. Croix County. So
Yes, that place.
yeah, I have a cousin that lives there and now I can't even remember the name of that place. So, all right. So go meet, go see, go do. And Mr. Sullivan, so you know, for the next time, I ordered it to be here and I would swear him in, but my court reporters for me today, I don't have a court reporter.
Understood.
So
I got in touch with the clerk's office and I think we miscommunicated. So I should have arranged to have our own person with us. So I apologize for that, but I think we'll be just fine.
okay, sounds good. All right, thank you. Then you can go on out, and if there's a clerk there, they can help you. Well, there will be a clerk there. They can help you, or Danny can help you go find the room, and then we'll go from there.